Now for our final lecture on legal reasoning, I will introduce the idea that reasoning in law is essentially about comparison and not deduction. So let's start by discussing the deductive model of legal justification, which is a model of legal justification that is very popular, but nevertheless is false. The deductive model of legal justification classically is presented through the legal syllogism. In the legal syllogism, we have a rule, we have facts, and then finally we apply the rule to the facts. So the rule could be stealing is punishable, then the fact could be that John stole, then the application of the rule to the facts is that John is punishable. If you look at it closely, you will notice that IRAC is essentially a more parsed out version of the legal syllogism. We have the issue in IRAC, which corresponds roughly to the facts, then the rule, which is the rule, and the conclusion, which is the conclusion. Where IRAC is more generous is in that it gives us one bullet point, one slot to discuss the application, to say something more about the processes of interpretation that take you from the rule and the facts to the conclusion. But if you just leave it as it is, you could still say that IRAC is a version of the legal syllogism. The deductive model of legal justification is misleading because it makes you believe that the action in law, the decisive point, is to get from this ready-made rule and ready-made facts to conclusions through a process of reasoning that is deductive in nature. But that's not how it is. Reality, as a lawyer, as a judge, as a legal thinker, you actually have to fight about why this rule and not other rule. Which rule should I apply? You also have to fight about the facts. Did John really steal? Maybe he simply took the bread. But he did not intend to steal it. What were really the facts that occurred? We must fight about the application of the rule because we might need to interpret the rule in a textual manner or in a teleological manner. Sometimes we can even fight about what the proper conclusion should be. And if you go way back to contract law, you will remember that there is such a thing as choice of remedies. So we could come to the conclusion that the contract was breached, but we may have to decide about whether the appropriate remedy should be termination or whether the contract should be continuated, whether the appropriate remedy should be compensation or performance. So all these questions, all these possibilities, all these branching possibilities, they get ignored if you believe that the main process of decision making is deductive. Because there are branching possibilities for all the bullet points, like all the categories of the legal syllogism or all the categories of the IRAC model. Essentially, what happens in law is not that you move from premise to conclusion, but that you have to compare different concatenations of rules, facts, and conclusions, or different concatenations of issue, rules, applications, conclusions, that is, different IRACs, and see which of the IRACs is more convincing. So, for example, with Obergefell, we had an IRAC that said, well, super summarized. The IRAC said that the issue was that same-sex people were not allowed to marry, that the rule was the 14th Amendment of the US Constitution, that in its application, it was fine to interpret this teleologically, and that as a conclusion, same-sex couples should be allowed to marry. That is definitely something that makes sense, that makes logical sense. But to get to that is not enough. That's not where you win or where you lose a case. Essentially, what happens is that you have to contend with alternative IRACs. So you would have, for example, reading the dissent, you could come up with the idea that the issue is indeed that, that states are not allowing same-sex marriage, that the rule is indeed the 14th Amendment, that the application of that rule, however, must be literal, and that if we interpret the rule literally, we can come to the conclusion that it says nothing about marriage needing to be extended to same-sex couples, because that's simply not something that's expressly considered or mentioned, that the treatment is not unequal, and that the conclusion therefore is that no legal steps needs to be taken because there's no clear breach of the 14th Amendment. Or you could even give a second IRAC, a third IRAC, that is even more distant than that because it challenges what the issue is. You could say, well, really the issue, really the problem with these same-sex couples today is not that states do not recognize same-sex marriage. Because of course it's quite easy to travel to California, to travel to Nevada and get married there. We are living in the United States where travel is very easy. Now, the real problem is that states do not recognize, that some states, that the very conservative states, are not recognizing marriages that have been legally made in other countries. So if a same-sex couple travels to California to get married and moves back to Tennessee where they live, then the marriage disappears. And if you say, well, this is the real issue, then maybe the rule would be different. It would no longer be the 14th Amendment, which is this idea of freedom and equality, but it might be what's called the full faith and credit clause of the Constitution, which says that the acts made on one state must be great, like the decisions, the rulings made by one state must be recognized by other states. And then without going for teleological interpretation, we could just go for literal interpretation and say, here we have a scenario where without any good reason, decisions made under other states are not being recognized, and then the conclusion is different. It's not so necessarily that same-sex marriage must be recognized everywhere, but simply that when states that have same-sex marriage choose to marry same-sex couples, that must be recognized in all countries, in Tennessee, in Utah, and Nebraska, and so forth. So here we have a third potential IRAC. And the idea of legal reasoning then is not to move from this generally accepted fact and the generally accepted rule to a conclusion, but rather the problem in legal reasoning is to build up a more convincing concatenation of rule, fact, and conclusion than the alternatives which may be presented by your opponents in court or by other judges in case they disagree with you. And now this is the crucial part, because the reality is not one where you win the case because of deduction. The reality is that you win or lose the case by comparison. It's actually easy to make a deductive argument in law. You just pick some rule, pick some fact, and apply it. That's the easy part. The difficult part is to show why your deduction, why your IRAC is better than the IRAC of the opponents, of the other judges. And that is a different game than deduction. And this is something that you must see very clearly. So the difficulty then in these three versions, like one IRAC which would support same-sex marriage, this other IRAC which would deny it, and a third IRAC which would support it, but not necessarily on grounds of fundamental rights, but on grounds of recognition of different state policies. Well, you would have to give reasons to say whether the first one is superior to the second one or the third one, and so forth. And these reasons will not be deductive in nature. They will be based on showing why this has closer connection to the law, better policy consequences, and so forth, why it's more just or less arbitrary. But this is no longer an exercise in deduction. This is an exercise in comparison. And the key issue is not to show that this and only this follows from these generally accepted premises, but to show that this theory is better than other theories and more deserving of the court's attention than these other theories. Essentially, once more, comparison and not deduction. And then how you would go about this? Well, essentially, this is the game of giving reasons. You would have to give reasons to say why IRAC number one, let's say what the majority of the court decided in Obergefell, makes more sense than IRAC number two. Let's say that would be the opinion of dissent of for example, Justice Roberts. And then you will have to say that your reasons are stronger than his reasons. And then that is a matter of showing and not of telling. And then, for example, if you simply say, well, there's going to be this negative consequences if we accept same-sex marriage. Okay, which ones? Elaborate. Tell me exactly what those consequences will be and why they would be so negative. If you tell me, well, that can lead to a change in the concept of marriage. Okay, but then why would that be bad? Demonstrate, show, argue. That's the challenge. Or alternatively, if you say, well, if we follow the path of legalizing same-sex marriage, we enter the territory of these cases like Lochner and Dred Scott, where the court invalidated a democratic process and substituted its own opinion. But then, is it really that similar to Dred Scott? Are we talking about a situation? Is same-sex marriage in any way comparable to slavery? Then I think, of course, if the moment you start to think about it, then the analogy breaks down. But you have to demonstrate it, right? One institution is autonomy preserving, the other institution is autonomy destroying. The point then is to not just say things, not just state conclusions, but take the effort of showing why these reasons are the ones that I have to pay attention. And this is one way of saying it right now, is to say that argumentation and rhetoric here come together. Rhetoric, that is the art of making your point visible, convincing, is exactly what is needed at the level of argumentation. I want to make one last point about why this deductive process is not the right mindset for the law. And because this is a very general point, I think it's a very useful one, because I think it will be useful for you more than just in law, but in any discipline where argumentation is essential. And this is the reversibility of arguments. And it also the form of the reductio ad absurdum argument. And here consider this first deduction, which is, as far as it goes, well, really, it's just valid, right? Let's say that we have this rule that says, interpreted literally, freedom of speech is unlimited. Premise 1. Premise 2, unlimited freedom of speech covers hate speech. Conclusion, hate speech is protected by freedom of speech. So that is correct as a matter of logic. As far as it goes, it's a valid deduction. Here's a second one. Interpreted literally, freedom of speech is unlimited. Unlimited freedom of speech covers hate speech. Conclusion, because we can't accept hate speech, we can't accept that freedom of speech is unlimited. That's another valid argument form. Then you could notice that it takes the same premises but reaches the opposite conclusion. This has been charmingly put as one person's modus ponens is another person's modus tollens. And it refers to the reversibility of informal argumentation. If informal argumentation, if following the rules takes you to a conclusion that you may consider absurd, and here I am not affirming that hate speech is absurd or vice versa, but I just try to show you the point of logic, that if following a conclusion of argument leads you to an absurd result, there's nothing easier than inverting the flow of argumentation and then attacking one of the premises because the conclusion is absurd. And this is not illogic. This is that this possibility that arguments are reversible in this manner is part and parcel of the logic of argumentation in law. So once more we go back to comparison. Which do I take? Do I take the modus ponens, where because freedom of speech is unlimited, I must then accept hate speech? Or do I take the modus tollens, by virtue of which, because I cannot accept hate speech, freedom of speech cannot be unlimited? Which one do I take? Do I take the conclusion or do I reject it as absurd? Well, the thing is that I can take both, and that then we need a comparison between the cogency of the two argument schemas to see which one is more deserving of adherence. So then the idea here is that we're back into this comparative scenario where arguing in law is just as much or even more a matter of seeing that this is more solid than that, then it's a matter of sequencing, because the sequence can be reversed. To conclude, this discussion about argumentation in law can also tell us something about the nature of objectivity in law. So we miss the point of legal reasoning when we try to label it as objective or subjective. This truly misses the point, because this sort of binary category would make sense if we were judging law by some sort of deductive standard that works like an on-off switch. Either the argument is subjective or the argument is objective. End of story. Well, that's not how it is. The logic of law is comparative in nature, and then to judge arguments in law, we should not judge them as if they're objective or subjective to court. Rather, we must judge them as being comparatively better or comparatively worse. And you will notice immediately that this is a much more tenable proposition. I cannot say, for example, that the majority opinion in Obergefell is subjectively right. I do not consider it to be subjective either. A much better question to ask is to say, well, is the majority opinion in Obergefell comparatively better than the dissent, or is it comparatively worse? Now, that question is much more amenable to inquiry and discussion, and it's much more natural to the law than the more philosophical question about whether it's objective or subjective, and leave it at that. So when you're reading legal texts and when you're assessing legal arguments, keep these two things in view. Where the action is, where you win or when you lose, is not at the matter of coming up with one argument, because that's easy. Where you win or when you lose is in trying to make the better argument, as opposed to the others that are presented by your opponents. And then when you assess what you've done, what you've assessed your legal work, do not assess it in terms of objective or subjective, because that will send you to the wrong path. Rather, assess it in terms of being comparatively better or worse, more convincing or less convincing than the other arguments.